I call Chris Bishop.
Thank you very much, Mr Speaker. I just want to acknowledge the member that spoke just before, Tracy Martin, and I think pretty clear from listening to her speech that she played a constructive role in the gestation of this bill, but also the improvements that have been made to this bill through the Select Committee process and also through the Committee of the Whole House stage. And I think it's also clear from listening to her speech, and I know the honourable member serves on a board of trustees in Auckland, in Rodney, and she has some experience in the school system, so has a not unique, but certainly some useful experiences to bear on this issue, which primarily, of course, affects the young, although not completely, but primarily affects the young. And so I think some of the examples that we've just had mentioned from Ms Martin have been a useful contribution to the debate. It's not often that Tracy and I agree, so we'll put that down for the record. Sir, this bill was introduced in November 2013, and unfortunately I didn't have the privilege of being in Parliament then, or indeed serving on the Justice and Electoral Committee, which considered the bill. But I have interrogated the bill and its principles pretty thoroughly over the last few weeks, and I'm very glad to stand here supporting it. Sir, the driver of this bill is really technological change, and it's one of the paradoxes really of modern society that privacy to individuals is becoming more important, whilst at the same time individuals feel free to place more of their lives online than ever before. They feel free to share photos, they feel free to put up photos of their cats, even likening them to politicians. They feel free to share their poetry online. They take Instagram shots of their food and place them online. They place their holiday snaps online. Previously you had to go around to somebody's house in the evening to watch a boring slideshow of their holiday snaps, whereas nowadays if you're really keen on seeing somebody at Angkor Wat or in Burma or anywhere, you can just log on to Facebook and see them straight away. The technology really is changing everything. The world's biggest transport company, Uber, owns no cars. The world's biggest accommodation provider, which is Airbnb, doesn't have any hotel rooms, doesn't own any buildings. So really the internet is changing everything. But with that, sir, comes new threats. And if you read the regulatory impact statement on this bill, it rightly makes the point that there are new threats for harassment, for abuse, for threatening behaviour, for the publication of invasive photos and invasions of privacy that come with this new technology. And if you read the regulatory impact statement, sir, it makes the point that Trade Me has 2.8 million users, which is actually quite astonishing. That's about 75% of the New Zealand population, assuming that each user is an individual person. 2.8 million individual users with 25,000 posts per day. And I think the regulatory impact statement was written about 18 months ago, so I suspect that figure is actually far higher now. If you look at Twitter, sir, there are 1 billion tweets sent per week. And again, sir, I suspect that figure is actually far higher now. So with these new technologies, sir, come new threats. In some ways, the traditional school playground has moved online. Growing up, I remember, we didn't have cell phones when I was growing up, or certainly they were a very nascent technology and they were too expensive. They were outside the realms of a chap like me. But I remember going home and logging on to MSN Messenger. That was a playground for abuse in my day. Was the famous MSN Messenger technology. Now sadly retired. Microsoft has got rid of MSN Messenger, but that used to be the thing. It's gone. It's gone, Mr Seymour. It's gone. And Mr Seymour's of a similar age to me, so he no doubt remembers as well going home from Auckland Grammar School, finishing rugby practice and all of the extracurricular pursuits. He no doubt pursued at Auckland Grammar and logging on to MSN Messenger to catch up with the very same people you've been talking to at school that day, but also people from other schools in your community. And that's gone now, but MSN Messenger was certainly a hive of certainly interesting and challenging behaviour. But nowadays, of course, very many students at school have cell phones, and they have 4G or 3G access to the internet. They even have Wi-Fi at schools, and a potential for students to bully and harass and make life misery for other students in the school has certainly been heightened. Sir, if you read the background work on this bill, something like 1 in 10 New Zealanders say that they've experienced harmful communications on the internet. That comes from the Law Commission, sir, and that figure rises to 1 in 5 for adolescents. Sir, and the Minister in her third reading speech outlined some very sad cases, which I won't repeat, of harmful bullying and abusive behaviour that take place over the internet in New Zealand society. So the question that confronts Parliament then, sir, is what is the appropriate legal response from the legislature to something that I think there is unanimity on in the House is poor behaviour? What should be the legal response? Well, the Law Commission did a review, sir, and it concluded that basically the existing remedies that we have in our law, like defamation, like harassment, like vilification, don't effectively address the potential for harm from these new technologies. So we have a lacuna in the law, sir. Now, there is an argument, I think, and that has been advanced by some people, that we should just rely on defamation law, that we should just rely on the existing civil or tortious remedies in our law, sir. And I think, with respect, and I think Tracy Martin pointed this out and others have as well, I think that is a little far-fetched to expect that we could rely on a 13-year-old or even a 16-year-old to rely on defamation law to enforce their rights against those who seek to violate them, sir. So I think that is a little bit far-fetched, and so I think the Law Commission, went through that and came to that conclusion as well. So we have this bill, sir, put forward by the government. So what does it do? It creates a new civil enforcement regime to quickly and effectively deal with harmful digital communications. That's its first major objective, sir. And secondly, it creates new criminal provisions that deal with the most serious conduct. And there was some debate, I think, about whether or not this should be a criminal offence included in the bill, sir. But as the Minister's made clear, I think it is correct to say that we do need that backstop provision for the most egregious, vile, the most reprehensible conduct, sir. And I think it is clear that is required. Certainly the United Kingdom has moved towards this. They've criminalised revenge porn, for example, sir. Australia, I understand, has had a law similar to this for a decade, sir, and there hasn't appeared to be many problems with that, sir. So how will this law work in practice, sir? So I regard it as a cascading series of options. So, or not options, but a cascading series of things that the law does. So firstly, the law sets up this approved agency. And it's very correct to say, sir, that the major priority for this new agency, the new approved agency, must have an educative focus. It must be well resourced. It must be seen as a credible authority in this area. And the Minister has given that assurance that will be the case, and I, for one, will be inside the government caucus making sure that is true. So it sets up this new agency. And then what we have, sir, are mediated outcomes. And the Minister has said that the vast bulk of the activity of the new agency and the vast bulk of complaints that take place under this new Act will be dealt with through these mediated outcomes. And I think that is appropriate, sir. And then, of course, we have the ability to apply to the court for civil orders, for takedown notices to remove material, and then, of course, the criminal sanctions that I've talked about, sir. Just in closing, sir, I want to briefly talk about freedom of speech, because Section 14 of the Bill of Rights Act protects that, sir, and is very important. I was concerned that this bill would potentially impinge unnecessarily and unfairly and unjustifiably on Section 14 of the Bill of Rights Act. So I went and looked up the Section 7 report, because of course the Attorney-General is required to report to the House if a bill is unjustifiably inconsistent with the Bill of Rights Act. But the legal advice is published, so I went and looked up the legal advice from the Crown Law. And sir, the legal advice from Crown Law is that this does not breach Section 14 of the Bill of Rights Act, or to the extent that it does, it's a justified limit, because they find, sir, that expressions can be limited to the extent necessary to avoid or redress serious emotional harm or other harm or the incitement of harm. And that is, according to the Crown Law Office, sir, a justified limit on Section 14 of the Bill of Rights Act. And that is, in essence, what this bill is trying to do, sir. So I was comfortable to conclude that this bill is acceptable and a justified limit on Section 14 of the Bill of Rights Act. Because of that, sir, I commend this bill to the House.